The European Parliament decided to do a report on the European Arrest Warrant. This is something called a legislative initiative report, and this is a relatively new formulation. It is under the Lisbon Treaty, and it is a facility to enable MEPs to call on if we so conclude, to call on the European Commission to make a legislative proposal for change.
Did we really do a system of pure mutual recognition? No, we did not. We, in fact, kept quite a number of hindrances to surrender, also in the framework decision. If you read it carefully, you will find that there are 3 mandatory ways of refusing an arrest warrant. There are 7 non-mandatory facultative possibilities of refuse, and there are 7 other possibilities for actually postponing a surrender.
The European Arrest Warrant system it's important to recall, is a framework which member states should cooperate. A successful European Arrest system is entirely dependent on the good cooperation between member states. And we think in the Commission that there is certainly room for better bilateral and multilateral cooperation by the member states in both individual cases and national systems. For example, to address the issue of proportionality.
What should be really considered on a political level, because this is a real level that has to decide, and with high importance, are the problems concerning Article 2, first paragraph of the framework decision, which provides a really low measure of punishment for an EAW. And I add the Article 12 of the same framework decision. A reasonable application of the detention, of the pre-trial detention by the issuing and executing EAW.
Europe is rightly proud of its commitment to human rights and the rule of law, and is eager to support the spread of these values around the world. And this is, of course, particularly important with the rising economic power of China and India. But we will not, however, have credibility if member states continue to be complacent, turn a blind eye, and act as slaves to mutual recognition and the flawed EAW system. In a speech delivered in 2010, Vice President Reding made this point clearly, explaining that we will only have mutual trust in Europe once each and every member state has earned that trust by showing its neighbours it has a criminal justice system that guarantees fair trials.
In principle, that there ought not to be a particular objection to reopening this instrument. It's remarkable to contemplate that a piece of legislation once drafted ought never to be reviewed. It must be the case in every national parliament that you have a criminal justice bill of some description every year. I certainly know in my jurisdiction it's never ending. That means that member states recognise that legislation has to be subject to review. This was the first mutual recognition instrument that was adopted by the EU. It cannot be the case that it was perfect in its first revision.
We may have a presumption of respect of human rights, but this must be rebutable, and it should be rebuted, and so give rise to a refusal of mutual trust, I would say, when there is a systematic violation of human rights. But then, of course, the question is to know what is a systematic breach and how do you show such a systematic breach. So I think it's a very, very complex question, even if we refer to the case law of the Court of Justice.
In order to allow a debate in the UK Parliament and in order to inform our government's decision to seek to opt back into the European Arrest Warrant, we're trying to go about reform in two ways. The first is the changes to our domestic law, which have been referred to already, and these are based on some of the existing practices in other member states. And our tour of capitals earlier in the year gave some good examples for us of how other member states within the overall framework of the EAW framework were able to take steps to address concerns for them, such as proportionality and trial readiness.
A nationality of a surrendered person cannot be a ground for refusal. So then the question that the Polish Constitutional Court had to answer was, is EAW a type of extradition? Because there was a large debate around it. I mean, I know that in some countries, like in the UK, it's just called extradition, but in Poland it was a hotly debated issue, which resulted in a judgment of the Polish Constitutional Court in 2005, which said that the surrender on the basis of EAW is a variation of the procedure of extradition.